This tutorial provides an introduction to the preparation of different forms of interim application, being applications made before trial and, in some instances, before the commencement of proceedings. Interim applications and the CPR. There are a variety of sections of the CPR that govern the form and manner in which interim applications may be made, with further guidance specific to the Chancery and Queen's Bench divisions and the Commercial Court. An application may be made that the court exercise its case management power in a particular way, or for a specific remedy, such as an interim payment. Types of case management order. Examples of the types of case management orders that the court may make include extending or shortening the time for compliance with any rule, practice direction or court order, staying the whole or part of any proceedings either generally or until a specified date or event, and dismissing or giving judgment on a claim after a decision on a preliminary issue. Upon making an order, the court may specify that there be some sanction for non-compliance, for example, that a statement of case be struck out for non-compliance with an unless order. Types of interim remedy. Examples of the types of interim remedy that the court may grant include an order for the detention, custody or preservation of relevant property, an order for the delivery up of goods, and an order preventing a party from dealing with his assets, whether located domestically or overseas. There is no requirement that the interim remedy which is sought have also been claimed as a final remedy in the proceedings, since the circumstances giving rise to the need for the interim remedy may not have been apparent from the commencement of the claim. Timing. An application may be made at any time and should be made as soon as it becomes apparent that the relief sought is required.